Good evening, all. Good evening. Very sorry and thanks to bear with me. I got delayed because of the following issue. Everybody is aware of it. Well, I have been given to learn that my speech is going to be less of a technical speech. It is more of a discussion which will perhaps help me and help you all. Help me to answer your queries and perhaps help you all in knowing what is the concept of administrative law that we are going to look forward with. So now, basically, everyone amongst here is aware about what is a litigation, because I am pretty sure that in every house there may be some or other litigation is there. Litigation need not necessarily mean it has to be a very lengthy civil matter. It could start with a very simple issue, like somebody has constructed a house, he is not getting an occupancy. Somebody is not in a position to get the electricity meter transferred in their name. Someone has an issue with a neighbor who has encroached into their property. Or there is a difficulty in maintaining your own house and you need a repair permission. But if you go to repair, there is a problem that is created by a neighbor. So you may have to seek permission from panchayat, from municipality, or if you are a munkar, from your bhatkar. And second type of situation would be, we are governed under the Goan law. So if there is a death in the family, then there is something called as inventory proceedings. If there is a litigation, somebody has filed a false case against you, or by mistake you had given a check, that check is bounced. There are so many, there is a vast horizon of different types of issues which one faces in their day-to-day life. So now when we are trying to come across administrative law, we are trying to basically explain one corner of law. Now, as I just suggested about civil courts, there are different types of courts. Now, for the purpose of administrative law, let me make it a little simpler. Administrative law. Now, how many people over here are aware of what is called as rule of law? Anybody? Basically, rule of law means everything has to be executed in accordance with law. Now, what is the meaning of everything has to be executed in accordance with law? As per our Indian Constitution, there is something called as Article 14, right to equality. It means equal protection of law and equal treatment to every individual who comes before law. So when we say administrative law, we come to the faculty of the authorities under the government, which are land revenue authorities, like Mamlatdar, Deputy Collector, Collector. Now these are officials who are appointed under the administrative section. These are not civil courts. Now, for the purpose of civil courts, the formation, constitution, and appointment, and the powers with which they are given a jurisdiction, they are different. In so far as administrative part is concerned, the powers with which they are given an authority, those authorities are different. Now, when we say Mamlatdar, Deputy Collector, we have certain concept of proceedings like Land Revenue Code, Munkar Act, Agricultural Tenancy Laws, Rent Control Act. Now, these are peculiar acts whose jurisdiction lies not with the civil court but with these officials. Whenever any particular proceeding is proceeded before Mamlatdar, Deputy Collector, or the collector, the manner in which they function, the manner in which they perform their duties, or the manner in which they exercise their obligations, there is where administrative law comes into picture. Now, basic concept of administrative law is don't charge me without hearing me. Do not take a decision abruptly. Don't take a decision arbitrarily, which would mean when I am aggrieved, I move before the authority. I expect the authority to first understand my grievance, understand the reason for the grievance, decide whether that grievance should be redressed and what are the means by which it could be redressed, and accordingly give a reasonable solution to it. When we say administrative law, as I just said, rule of law, which means we expect every authority to act in accordance with law. None of you all over here who move an application will expect that they will get some answer, they will get a call, they will get some information. What happens when you don't receive anything? It is an irresponsible behavior. So that starts at the inception, that when a particular complaint is filed or when you approach any authority, the authority is expected to act in accordance with law. That expectation is rule of law. It has to be followed with what we call as principles of natural justice. Now, when we say principles of natural justice, even if you go on Google, it sounds very nice, principles of natural justice, but what exactly does principles of natural justice mean? When you say principles of natural justice, it means basically two doctrines. First is you have to hear the other side so that before you pass any decision, you are aware about both the perspectives. And second thing is, no person should be sitting as a judge deciding any matter in which he has his interest. Most of the times this happens in the panchayat meetings or in the municipality council meetings, where you want some license to be issued. One neighbor gets a license, the second fellow will not get a license. So that should not happen. Third thing, when a decision is given, now anybody's proceeding is pending, if an order is passed declining your request, it is not necessary that definitely nobody would like that his request is declined. But when a request is declined, giving a reason that these are the following reasons why your request cannot be granted, the amount of dislike or amount of dismay that every one of us will face when we are aware why our prayer or why our request was not granted would not be that much if your application is dismissed in one line saying that application is not granted. At that point of time, we come to conclusion that either he has been bribed by the other side or whether he has tried to take sides. So basically, administrative law is a principle of transparency. We expect that whenever we approach authorities, the authority should be transparent. We should be given proper justice and we should be heard. The problem comes when we don't get these basic three principles of being heard, of being given proper opportunity, and whenever any decision is given to us, that decision is given without any reasoning or any logic. Now, just for the sake of an example, anyone amongst here are having any inventory proceedings pending, just for the sake of an example? Madam, now, in an inventory, if you are told, certainly these are legal circumstances, but there is something called as chart of partition and chart of allotment. Now, inventory is basically applicable only to goans. Now, who is a goan? There is a big issue where we say that "Aam goikar, tu goikar." So, it has been very clearly explained that those whose parents or whose grandparents were born in Goa before the liberation are the beneficiaries who can take over the benefits of the Portuguese law. Many people have a habit of saying that no, his marriage was registered in Goa, so he becomes a Goan, or he migrated to Goa, settled in Goa, so he is a Goan. Goan law is not applicable by way of a overlap unless the requirements of you being a Goan is made applicable. Now, why did I say this? In most of the places, there is a system of will. In Goa, there is no system of will. Even if a will is made, that could be challenged because we are governed by the system that when a person dies, if he has died without leaving a will or without disposing his last wish, then we consider that the authority is given to the inventory court who will, as per the succession, as per the assets left, and as per the liability of the creditors and debtors, would decide how to distribute the asset amongst everybody. This inventory proceeding is one of the best means or a best example of how administrative law has to be exercised, because now inventory court would definitely not know who would be the legal heir unless it is being told. There are many situations where the legal heirs are suppressed, then the properties are not brought on record, then the debtors and creditors of the party also are not known. In such circumstances, normally the inventory court would go in for a direction to make publication. Basically, reaching out to people, making them aware and making them know that these are the situations which are happening in the daily affairs, so that the person who is affected would reach out to the association, to the court, and express their grievance if they are so affected or not. Coming to the aspect of Human Rights Commission. Now, can anybody with whatever means or whatever idea they have, has anybody appeared before Human Rights Commission? Can you, sir, explain what was the reason that took you to Human Rights Commission?
I appear as a government support. Okay. Because the Human Rights Commission on Sumoto, they had taken cognizance of one road which was deteriorated. Because of that, I had to go and reply.
So whom did you file a complaint against?
I was not a complainant. Okay. They took Sumoto cognizance of the bedroom.
It means you represented your office. So many times it happens that mostly I have come across in my field of practice, many senior colleagues or senior citizens often approach me saying that they are being tortured or they are being aggrieved by certain actions or certain decisions of their family members. They are not given food, they are tortured, they are kicked out of the house. Whether Human Rights Commission could intervene because their human rights are taken away. Here I will just halt and I will just take through some acts which perhaps could be a little interesting. This is with regards to criminal law. Now, when a person commits a crime, an adult commits a crime against another adult, that individual will be treated under the Indian Penal Code, which is now BNS. If an adult commits a crime against a child, the authority that would be taking cognizance of this offence would be the children's court. Now, if the person who is committing a crime is not an adult and is a minor, in these circumstances, there is juvenile justice court. So basically, for every different perspective, there are different authorities. Similarly, in a circumstance where you have to raise any grievance with the Human Rights Commission, Human Rights Commission could be approached only when a human right has been taken away in such a fashion that it has been taken away by state authorities. Human Rights Commission is not available for you to initiate action or file a complaint against private individual. It has to be an authority, a state authority, who is expected to perform a particular act. However, they have gone far beyond that state and they have not performed that act. Again, in human right, a non-fulfillment of an official's duty did not necessarily mean a human right violation. A recent incident, police arrested a mother and a child. Now, she was caught in a theft. The child was around 7-8 years. She was put behind bars. The child was kept away from the mother. Complaint was made before the superior official. There was no action taken. Then a complaint was made before the human right. This situation took place in somewhere around 11:30, 12 o'clock. Unfortunately, we did not have a proper working system for the human right, so human right was approached early morning, and accordingly, they directed that this issue has to be sorted. Now, when a police commits a mistake, a police also can be taken cognizance of, or his actions can be taken cognizance of, but not necessarily every action of an official should be taken up before the human right. For an action to be taken before the human right, the action has to be so heinous and it should be totally out of his working concept. Only then human right will look into it. Otherwise, there would be no proper grievance redressal that you would get from human right. Any particular question anybody would like to ask, please?
Is inventory a title?
Sir.
Does the inventory establish title?
Sorry.
Does an inventory order,
Yes, sir.
does it establish title?
Now, title is established by different means. Now, inventory would establish right to succession of the person who holds title to a property. So, by virtue of inventory, the person who has expired and the property that he owned will be devolved on his heirs, and the court will decide the share and proportion which will be given to each heir. So, in that manner, it will hold title in terms of share. So, once an inventory order states the proportion in which the right is granted to each heir, based on that order, then it can go for partition or it can go for separation by metes and bounds, or based on inventory order, civil suit can also be filed for declaration. So, inventory is a link between a person who has expired without having his last wishes documented to the future generation.
There is no declaration in the inventory.
I'm sorry, sir.
There is no declaration.
There is no declaration. There is chart of partition and chart of allotment.
So, when there is no declaration,
Yes.
how do you prove he is the owner?
I beg your pardon.
How does the court prove that he is the owner?
Now, when a person dies,
No, that's how I understand you.
Yeah. so how do you declare who is the owner?
Yeah, how does the court establish that he is the owner? Because they are not giving a declaration.
No. Like for example, the person who has expired, if he declares, I just.
So, you are taking a point
Yeah.
that HOI, that is the head of the family,
Yes.
has to make a declaration. Which has not been done.
Normally, when in an inventory, a property is decided to be succeeded to his heirs, the title of the property has to be submitted in the court. Without the title being submitted to the, because inventory is a process of succession and right of proportionate heir. Without the document or without there being a ownership document, you cannot initiate inquiry.
Court does not look into the documents of the insurance. Doesn't look into it.
It should look it.
Yeah, it should.
It should look it. That is the process.
And I know in the case,
I see.
child fighting case,
Yes, sir.
I can mention and you can go to the record. 137 of 2010.
Yes, sir.
13 years passed. Till today, he has not given the statement and
It is very unfortunate. What you are saying is correct. It should look into.
that
Without you look into the origin, how can you decide what would be the next step of that particular? You are right, sir. I'm sorry. In such a case, when any particular proceedings are going incorrectly, either it has to be brought to the notice of the court by virtue of filing a proper application. If it is dismissed and there is no approach to an appellate court, the proceedings can be directly taken to the High Court under a writ jurisdiction, and the High Court can give directions to the court saying that a particular error has been committed which has to be put right.
So that is what you have done, I guess. Because so many years, 13 years.
No, sir, what happens? What happens? Sometimes unfortunately, things remain unsolved. So, the moment you realize that there is an error, you can immediately take steps. Till the time you don't, sometimes what happens, you are going in the wrong direction. The time arises only when you realize that you are in the wrong direction. So, like how sir said, that when the court has not looked into, it could be brought to the notice of the court, and if the court still is not of the opinion that whatever you have said is correct, you always have a route to approach the High Court.
after the order.
Yes. No. I just correct myself. To my knowledge, what I understand is, we imagine that the court is going in the wrong direction.
That is what I thought.
We understand court is going in the wrong direction. The moment we realize that, we move. There must be something which the court is doing for us to understand that the court is going in the wrong direction. There will be Roznamas passed or something. It need not necessarily be a final order. Some interim order or some interim procedure which the court is following. An application, sir, with respect could be moved, challenging that procedure, so that otherwise the entire process conducted by the court is futile. And based on that, under 227, under the superintendence of the Honorable High Court, as you will be aware, a writ could be filed, so that if the court agrees, then court can appropriately pass direction.
Now they have amended last year. Section. They have made that the government has
Inventory.
Sir, if the government department is not acting, then I can approach to Human Rights Commission.
Now, if a government authority is not acting, there will be different ways of his act. For example, if he is not acting, in the sense if he is not doing his duty, you cannot go to human rights. You will have to go to the authority to seek direction against him. Now, if his actions are causing damage to you, by virtue of which your human rights are being prejudiced, then you can approach the human right. Because it should not happen that you approach the human right, and when the human right goes through your complaint, if the human right feels that there is no element of human right violated, and what is violated is his right of duty towards you, then the human right may, on preliminary objection, dismiss your claim.
So my point was, I have made a complaint to Panchayat, Mamlatdar and Deputy Collector regarding the encroachment of road. Almost a year has been passed, nothing is only noticed, nothing has been done. So I thought that better to go for human rights.
Human right will not intervene. Here, the best option is you have to file a writ petition saying that despite making complaints of encroachment, authorities under the state are not acting, and they should be directed to look into the matter and take proper cognizance. If you go to human right, now human right is now, for example, I'll give you an example. If any action is taken against you which deprives your fundamental rights, which is required for you for your right to life and right to liberty. Now, with this road incident, what is happening is the officials who are supposed to do their duty and who are supposed to act on your complaint have not acted. You basically want that your complaint should be taken cognizance of, and accordingly, if the encroachment is continuing to exist, it should be stopped. Correct? Yes. So in those circumstances, it will squarely not fall under human right. The approach for you should be to the High Court.
Article 21 violated by
How?
access is not getting for public.
Article 21 is a constitutional remedy. Human Rights Commission cannot enter into it. It will have to be entered through the High Court.
So you mentioned that an inventory can supersede a will. Is that true? I mean,
No. Inventory cannot supersede a will. But what happens is, insofar as the law applicable to humans, if a will is made, and if the will is arbitrarily made, imagine I have 3 sons, I have given everything to one son. Other fellow can challenge it, saying that it is not a correct manner of document, and he can go to the court by way of an inventory and challenge this particular will by way of a suit. So, inventory and will, these are two independent matters, but for us, if a will is not acceptable, then we can,
only if there's a fault in the will be.
if there is a fault in the will, or if you think sometimes you would want, sometimes it can be a situation that you are enjoying a position of property which is much more, and you would want to purchase the share of your heir or of your sibling. But then if the sibling is not interested, so whenever there is an issue pertaining to a will, you can approach the will.
In your case, we a lot of times say women who are married off would be saying that they've given their share at the time of marriage.
I'm sorry?
At times, in the will it is mentioned that your daughter is married off and the share is being given at the time of marriage.
Correct, but whether there is any proof to that, it is just a statement of the person or the testator. So what normally happens, initially we used to follow that process, that once a girl child is married, the gold is given, Srinan is given, she does not have any share in the property. And issue used to come at the time when the property prices have shot up. And now there are litigations from the sister side where they say that we have not received anything. Because once the family gets disintegrated into separate families, certainly the issues come. So in a circumstance where a will is being made, there has to be some proof of things that have been given. And you can mention that whatever I am giving to a particular heir, it is from my disposable quota. So if it is from a disposable quota, it is your right whether you give it to whoever you wish. So any will has to have these characteristics.
So, good of succession. Or
Okay, so basically the intent is that there should not be a situation where you are kept remediless. There are many queries. What to do, where to go, how to go, whom to approach. If he is not doing it, then whom do I go to? So basically, we are running into a system of hierarchy, like how Sir raised queries. He has faced a situation where do we go and how do we go? Now, one thing I would like to tell you all, that there is no one route or one road. There can be many roads. It depends on which road you want to select. Many times it is that I have one opinion from A, I have another opinion from B, I have another opinion from C. That does not mean that an opinion given by A is different from B and C. So B and C are wrong. Or because maximum people are giving one opinion, the person who is giving other opinion is wrong. It many times so happens that those who know, like for example, now there are many people who are vegetarian. There are many people who are non-vegetarian. There are many people who are vegetarian. So can we say that those who are vegetarian, can they say that non-veg is poison? Or those who are non-vegetarian, can they say that those who are eating eggs are poisonous? No. Or they are different people? No. It depends on your choice. It depends on the feasibility of what you do. Now, if one person practices in all the forums, he has got the expertise or he has got the knowledge of what happens in all the forums. So he has a better exposure to guide and to give an opinion. Simple example, as my respected colleague just raised a query, that I filed a complaint with the panchayat. I filed a complaint with the Mamlatdar and deputy collector with regards to the road encroachment. There is nothing that has happened. Now, how do we look at this? We can look at it from different perspectives. For example, now he can file a civil suit in a district court where he can make the government departments a party. But then, in those circumstances, he has to follow certain procedures of issuing notice. If there is a urgency, then there is certain manner in which he can proceed. That is one part. Secondly, he can directly approach the High Court. High Court can directly take cognizance that when you have been told that these are the things happening, why have you not taken the call on it? You look into it. These are two ways. Going through a civil court will take a larger time compared to what we can get in the High Court. But now, in a civil court, he will have to first prove that his right is being violated, for which he will have to prove his right to title to the property, or his right to show that he has a right to stand before the court to raise a claim against the authorities, which is not necessary when he goes to the High Court, because when he goes to the High Court will look into the fact that a complaint is made to an authority and authority is not acting. So when he goes to the civil court will look from his perspective. If the civil court does not find him having a locus in that suit, perhaps he may not get a relief. If the High Court does not find that the authorities have done something wrong, on the contrary, if he has come with a false complaint, then accordingly appropriate directions perhaps may be issued against him as well. So, any problem can be pursued through different modes. So, merely there being one mode proposed to you does not mean the second mode is incorrect. Now, coming to the hierarchies. In administrative system, we have three scenarios. The first scenario is an interdepartmental scenario where any activity is done or anything which is done in an incorrect manner, the department will first look into it. There will be inquiry in that department itself. Now, after that department inquiry, if nothing fructifies, then the second forum or the second level of hierarchy would be within the government sector, who is superior to that particular department. From the second hierarchy system, it goes to the High Court. So, similarly, like a Mamlatdar, deputy collector, then we have an administrative tribunal, it goes to the High Court. Civil court, where there is a junior division, then it's a district court, from district court it goes to the High Court. Similarly, panchayat, from panchayat it goes to the BDO, it goes to the deputy director, director of panchayat, it goes to the district court, and then it goes to the High Court. So ultimately, every situation lands finally into the High Court. Now, this is because we in Goa, we have appellate High Court. We do not have an High Court of original jurisdiction. We cannot go with the grievance before the High Court at stage 1. We have to go, we approach the High Court at the last stage when there is no other remedy available to us. So basically, when you approach the High Court under 227, which is called as the superintendence powers of the High Court, where the High Court has the right and the powers to delve into any actions or any proceedings, like how Sir just said that a court was not doing something correct. Then once it is known that it is not being done correctly, you could approach the High Court. If the High Court feels no, but the court is doing right, then the High Court will pass appropriate orders. If it feels that no, it is doing wrong, then perhaps they will pass certain directions and guide it in the right manner as the grievance was proposed. So, there cannot be a scenario where you have no remedy to a grievance. Grievance to a remedy is always available. But now, these examples which I gave, where you reach the High Court, there are certain examples where High Court does not have jurisdiction. for example, nowadays we are very strongly seeing issues that are coming because of the CRZ. All the CRZ zones, there are CRZ 1, CRZ 2, CRZ 3, CRZ 4. Now, this is a body, that is the Goa Coastal Zone Management, in which there is a National Green Tribunal. So, what happens? Any grievance which is raised before the CRZ, any decision against that, it will not go to the High Court. It goes to its second hierarchy, which is the National Green Tribunal. And from National Green Tribunal, the appeal provision is directly to the Supreme Court. So, if you approach the High Court, when there is alternate remedy or alternate jurisdiction or forum available, High Court will not High Court will not look into the matter. Now, when I say this, any complaint, like also said, we went to the panchayat, but it is a public road. In a public road, panchayat may not have jurisdiction to intervene. A complaint made, because for a public infrastructure, then normally what is done is government acquires the land. After the land is acquired, there is a particular procedure under the Land Acquisition Act. Once it is acquired and once all the procedures are complete, we will have to show how there is encroachment of the road. For that purpose, he will have to secure the order copy, the plan copy, and he will have to show how his complaint of the road being encroached can be indicated from that plan. In case if there is anything that can be visible from the plan to show that the road has been encroached, immediate relief that he can get is by going to the High Court, because the government has acted arbitrary to its plans or to its acquisition. But by making a simple complaint to the panchayat has got no jurisdiction. Panchayat cannot even dispose the complaint. Even for the panchayat can only do one thing, that we don't have jurisdiction, therefore we will close the door. Because for the panchayat to act, panchayat can act only within the four corners of the Panchayat Raj Act. Anything which is beyond the scope of Panchayat Raj Act, panchayat will not act. Now, second thing is, he is also made Mamlatdar a party in deputy collector. Now, we have Mamlatdars for several departments. We have deputy collectors for several departments. If at all the complaint goes to the deputy collector or the Mamlatdar of the right department, then perhaps he may get some response. Otherwise, he will not get that response also. When he approaches the higher court or the high court, the complaint filed, because the honorable AG or the government is always represented by their lawyer, there any complaint which is filed, it will be routed to the proper department based on which the grievance will be redressed. So the question is, when we approach, whom do we approach? Whether we have approached the right authority. Only and only if you approach the right authority will the second stage start, where your grievances are to be addressed. If your approach is to a wrong authority, then it is like you are pushing against the wall. Nothing will happen, you will just be waiting. So can I ask you a question, please?
So, good evening, sir.
Yes, sir.
I think, may I make a suggestion as a sound engineer? But I have a question.
Please do, please do.
You don't have to raise your voice so much, that's what I'm doing. If you speak in the microphone,
Yeah.
softly. The question is the issue about NGT, which you just brought up, that we cannot, according to you, we cannot approach the NGT until we approach the CRZ, correct?
No. I'm just clarifying.
Okay.
When I made a mention about our High Court, we don't have original jurisdiction. We have appellate jurisdiction, which means a complaint or a direct petition cannot be filed in the High Court over here, which can be done in Bombay. Here, actions which are taken by the authorities which has caused grievance to you, those are appealed or those are taken into writ jurisdiction before the High Court. Now, under the NGT has original jurisdiction as well as appellate jurisdiction. So, if you file a complaint with documents before the CRZ fails to take action, or CRZ takes action which is contrary to what you think should have been done, you can file an appeal before the NGT.
Okay.
But you can also file an original application before the NGT directly.
Okay, that was my concern.
So where you make the CRZ a party and then NGT will give the directions.
Sir, I need to ask a question.
Yes.
This is regarding the hierarchy.
Yes, sir.
So you said first the panchayat, from the panchayat to the BDO,
Yes, sir.
BDO to the deputy panchayat, director of panchayat, and then director of panchayat.
Yes, sir.
Can you explain, if it's possible,
Yes.
that you go directly from the panchayat to the director of panchayat, what would be the circumstances? Bypassing BDO and deputy.
That's all. So now you will be governed under the Panchayat Raj Act. Now you will be governed under the Panchayat Raj Act. So under the Panchayat Raj Act, there are various issues. For example, if there is any illegality happening, then Sarpanch can issue a stop work notice, for which there is no requirement of a body meeting. But the notice which is issued will have the life up to the body meeting, because then it has to go to the body meeting and thereafter it will be confirmed by virtue of a resolution, and accordingly the stop notice which was issued by the Sarpanch will consequentially be a document of stop work order which will have been signed by the secretary. Now, in a illegal construction, if you are found doing anything wrong, or if you have constructed something illegally, then the hierarchy is clearly defined. If I file a complaint against you for illegal construction, Panchayat fails to take action, then I had to go to the deputy director. Deputy director would assume powers, and after assuming powers, deputy director would step down into the shoes of the Panchayat and conduct a demolition. Similarly, if Panchayat takes action, now there are two sides to it. One is when an authority takes an action, what you do. When the authority does not take an action, what do you do? So in a situation where action is taken, you have to follow the hierarchy. In a situation where action is not taken, then where do you go? So here, as I just told you, when the Panchayat fails, you go to the deputy director. Deputy director fails, you go to the director, as per the provision given. Now there are situations where you file a complaint, there is nothing done about the complaint. Then you directly go to the High Court in a writ of mandamus, as it is called, so that the scope of that petition is only a direction to that authority to take an action. And if the High Court feels that the authority is redundant and it is not doing anything, and there is an illegality which is flagged, then perhaps High Court will grant interim measure that we have to stop it, and then it will leave to the appropriate authority to take authority. So similar issues are with house tax or with any miscellaneous application where there is no appellate authority provided in the Panchayat Raj Act. You file an appeal before the BDO. So all these authorities before whom you have to go for a trade license, for shop and establishment license as well, there are authorities who are already mentioned in the Act. Under that particular section, you will automatically come to know appeal will lie before whom. So it is not that you have to approach any authority randomly.
No, because the case here is
Yes, sir.
that the house is pre-dating liberation.
Okay.
And Panchayat sent notice saying that it is illegal. We gave them all the answers. They accepted it. They passed a resolution. But in that interim period, the High Court said that the Panchayat will no longer be the defining authority.
Okay.
They passed it on to the CZMA. Okay. So then CZMA issued notice. We replied to that notice and we got a clearance. Yes, this is an old house, so it does not fall. It's related to even the 1991 survey that was done. After this, the Panchayat again sends us a notice some about 1 month time, saying that please show cause why a house should not be demolished.
Now, is that based on a complaint or it is suo motu?
No. This suo motu was taken by the High Court, and the Panchayat came and I believe they did an inspection which we also regulated, which we did not agree with. And they gave us a notice. We answered. Panchayat took a resolution saying that yes, it is legal because it is pre-dating whichever even the CZM. But in the interim period, High Court took a little bit of a guidance and said that the Panchayat has done some illegalities. So we are taking away this power from the Panchayat and we are vesting it with the CZM. Now the CZM, when we appealed to them, they accepted and said yes, no problem, your house is old, so it does not fall, it is legal. After this, can the Panchayat again send me a notice?
CZMA's decision with regards to the house is from a different perspective. Wife's sister is sister-in-law. For the wife, husband's sister also is sister-in-law. But they will differently relate to you or her. Panchayat will issue you a notice from the Panchayat Raj Act's perspective. And if the High Court had said that you have no business to interfere, I think in reply you can definitely provide the copy of the High Court order again. And secondly, if your house is old, as you said, it is pre-liberation, it will definitely be seen on the survey plan.
Yeah.
So if it is on the survey plan, then Panchayat has no business to intervene unless on the same plinth area, if there is some additional construction done or if the plinth has been extended, if the Panchayat notice clearly establishes that the reason for them to issue the notice is an aspect beyond the scope of your response earlier provided, then you will have to tackle it in a different manner.
No, fortunately, we have not done any.
No, I understand.
Thank you.
Yeah.
I think I got a little bit of your answer. Thank you, sir.
Yes, sir.
I've got two questions.
Yes, sir.
One is, can a notice of inspection
Yes, sir.
issued by a sarpanch
Okay.
can be stayed by director of Panchayat? That there is an additional director of Panchayat what is signed. Notice of inspection.
You can note down there is a writ petition number 735 of 2010. Writ petition number 735 of 2010. If I am not mistaken, it is something Bolu 9 as it goes back. What it says, here what had happened, I'll slightly go in depth. Here what had happened is, notice of demolition was issued at the signature of Sarpanch. Even today, most of the Sarpanches issue documents. Sarpanch has got no business to intervene. Sarpanch has powers under section 64 of the Act. Anything which is there in section 64, Sarpanch has power to do. That is, anything which is in connection with development of village or accounts or holding about the accounts, then it's clarified. When it comes to issuance of show cause notice, site inspection notice, normally what happens is, site inspection notice is for what purpose?
Illegal action.
Correct? Sarpanch can only issue stop work notice. As per section 64(1)(j), the reason why Sarpanch can issue stop work notice is any illegality prima facie which is brought before him. He can stop it, and every 15 days the body meeting is taken up. If at all the urgency is there, then they can convene an extraordinary general meeting immediately after the stop notice is given, and resolution can be taken on that very day and at the hands of, because secretary is the administrative head in panchayat. So any such particular grievance is there, they can immediately call for an extraordinary urgent meeting. They can take a resolution, and accordingly that stop work which was stop work notice which was issued will convert by way of a resolution into an order from the secretary in which inspection notice also can be issued.
So it was signed by secretary.
It was signed by secretary. Then yes.
It was signed by secretary.
Yes.
He is stayed by the additional deputy director of Panchayat.
That must have been stated in an appeal. Because when it was stated by who?
Additional deputy director of Panchayat.
It is additional director of panchayat. That is because director of panchayat normally takes up matters which are constitutional matters connected to election, removal of sarpanch, and there are delegated powers are delegated to additional director one who takes jurisdiction in north, additional director two who takes jurisdiction in south.
Actually, just starting of any issue, that can be also stated. What I must say.
See, that is the legal irony. But they have any particular. Your first question is whether sarpanch can issue. Sarpanch can issue whatever is provided under section 64, and section 47 of the Panchayat Raj Act clearly shows that any act which is taken by way of resolution will be executed by the secretary.
The second question is regarding human rights.
Yes, sir.
So, if any order is passed by human rights, whether it is he has to follow or it is just recommendation.
See, it is a recommendation, but even in the recommendation, what is the nature of order that you have to see? If it is in the nature of a binding order, then you will have to move the appropriate court and then get it executed. But normally, Human Rights Commission will always look into the fact that human rights are not violated. And always their orders are in the nature of recommendation, because based on that, respective court or respective authority under which act the right is violated, there are animal rights also which are violated. So based on that, the forum which is provided under the respective act will have to be approached.
So my question on Human Rights Commission.
Yes.
Sometimes innocent citizens they face police atrocities, and sometimes their fundamental rights are violated, especially in the police stations. They are falsely implicated. So my question is, shall they directly go and file a petition in the Human Rights Commission, or first they should go to the State Police Complaint Authority?
Now, here, if a human right is violated, there are so many petitions which are concurrently filed before the Human Rights as well as the Police Complaint Authority. Now, before the State Police Complaints Authority,
Yes.
those complaints have to be filed where the duties of the police are violated. Now, duties of the police are violated means not omission in those duties. Like, for example, my job is to get out from here and get in from here. If I jump through the window and I go, that is not supposed to be a part of my curriculum or my activity. That would come within the human rights. For example, I incarcerate a wrong person for no reason. That will not be human right. That, in my respectful submission, will be you go before the Police Complaint Authority. And there are other authorities like courts also. But court will give relief to the person who is incarcerated, and Police Complaint Authority will verify whether the conduct of the police was correct in doing that. But if I incarcerate a person and I deprive the person of food, I deprive the person of clothing, I just switch off the cameras and I beat up the person. There would be overlapping areas where a complaint will be before the human right also. But human right would immediately come to your rescue, saying that these things which are going wrong has to be discontinued. Whereas Police Complaint Authority will take action against the wrongdoer.
But can we get compensation, sir, because of police falsely implicating in the case?
Now I'll tell you one thing.
Because there was one case I just want to point it out. In Asgaon, there was one guy. He had gone few years back. He had gone to the Anjana police station. He had complained. The complainant, that guy only got pressed by the PI. And recently, I think last year in 2023, Human Rights Commission had slapped rupees 5,000 as a compensation for that the then PI police inspector. So can we get compensation if any citizen faces such type of atrocities?
Even in compensation, it depends the authority sitting on that chair, whether to what extent the authority has jurisdiction to grant compensation. For a simple example, in a suit, in a case filed before the court, now there are two things happening. One is, I rob you. So when I rob you, I rob some items from you which are of high price, or I rob you of your gold jewelry. Everything is established. Now, when you file a complaint against me with the police, it is for registration of theft against me, so that I will have to be taken up as per law. What does it mean actually? Because I have committed theft. Here the question of compensation does not arise, because the proceeding under which you have taken action against him is to take action against him for the wrongdoing. When you file a civil suit for recovery for the damage caused to you, when you establish the damage, and because of that you had to file the litigation, the cost of litigation. If you justify in proving it, or if you are able to justify how the court, whether the court is entitled to grant you compensation, then the court can grant you compensation. So, but Human Rights Commission per se, there will be limit to an extent to what compensation it can be, because it is particularly human right. It will see that rights are not violated.
Yes, thank you, sir.
Good evening, sir. My question is regarding illegal construction. If there is a complaint about illegal construction and Panchayat is issuing a notice for inspection, then who should be there in that inspection committee? Is there the requirement of civil engineer should be there, sir?
Now, what happens is, if it is illegal construction, the only thing that will be looked into by the Panchayat is, if it is illegal, it has to be demolished. So, if it has to be demolished, civil engineer is not. Now, only problem is, if it has been decided that the entire building has to be demolished, then the block development officer will have a demolition squad, in which authorities from various departments like electricity, water, and even ambulance to that effect will be there, so that while conducting or carrying out demolition process, if any casualty is there, so
If a suit goes for non-prosecution,
yes,
then you file compensation.
against whom?
It is a plaintiff has filed a suit against me.
Yes, sir.
And it comes to the evidence, he disagrees.
Okay.
He doesn't want. He gives all kind of. Then the court has no option.
Court dismisses it.
Dismiss it on non-prosecution. What do I do? If the court,
The defendant.
as a defendant, for 20 years, I have gone up the walking. I have put all my documents, and now at evidence stage, you run away. What happens to the expenses that I have incurred?
And sir, with due respect, you will have to initiate proceedings for malicious prosecution. That's
So, through my personal experience, what I've seen is the advocates who are appointed by this panchayats from the government panel, they do not file their reply. Say there is a case going on in Directorate of Panchayat, okay, and the person to whom the demolition order is served, he files an appeal, okay.
comment.
Say there is an illegal construction and someone has complained against it. Okay, Panchayat takes action, follows the procedure, issues the demolition order. The person to whom the demolition order is issued, he files a appeal at Directorate of Panchayat. So, in the first hearing that is scheduled, his advocate comes Panchayat doesn't appoint any advocate. He takes an ex parte say, goes. Then there is a hearing after 3 months. Panchayat appoints an advocate, he doesn't file a reply. The case keeps going. Say, I am the complainant of the agreed court. I file an intervention. Intervention application is served to both the parties, appellant as well as the respondent. Then a couple of hearings happen and they don't appear for any future hearings. The case keeps going on for 4 years. My question is with regard to the advocates who are appointed by the panchayat. They are being paid for every hearing. They don't file a reply. Panchayat, if you complain to the panchayat doesn't take an action. So, is there anything in administrative law that you can use as a remedy to take action?
Now, here what happens is there are many factors involved. I will give you a classic example of one matter which I was handling. Construction is legal. Construction is legal, but there is a dispute between the owners of the neighbors. One neighbor is good to the panchayat. Second fellow is not good nor bad. He is into his own work. Now what happens? And here the issue of CRZ is involved. So my client has permissions from CRZ. He has got each and every permission available. Now panchayat issues a demolition notice to me. I file an appeal. In appeal, my neighbor who is the complainant, he files an intervention. Unfortunately, the stay is not granted for a simple reason that the court says that as per the Panchayat Raj Act, there is no specific provision for granting stay because section 66(7) says when an appeal is filed within the period of limitation, the decision of the director is final. What does that mean? It indirectly means once you are before the director, but within the period of limitation, then whatever director shall decide that will be final. This is what the situation is. My appeal is pending. The panchayat demolishes the entire structure. Appeal is still pending. There is no reply filed by the panchayat lawyer to the appeal file. I file a petition before the High Court. My matter is pulled for 3 years. The structure is demolished. 3 years I am before the appellate court. The director of panchayat refuses to take the matter. Whenever the matter comes, I am given the next day. Matter comes before the High Court. It comes before the Chief Justice. The Chief Justice says what remains. Structure is demolished. Go file a suit against the panchayat and take your compensation. So now coming to your question. Now here, like our even sir proposed a query that now whether the plaintiff is not giving instructions to the advocate or he has not paid the advocate. So advocate's job is as per the instructions. Now who is playing a fool? Whether advocate is playing a fool, if advocate is playing a fool, that could be verified, a complaint can go before the bar association. If the plaintiff is creating a problem, then you file a proceedings against him. In your situation where the matter is just being prolonged for how many months?
4 years.
4 years. Very simple thing. Approach the High Court with the.
I have already done that.
Approach the High Court with the Rojnamas. Make it clear to the High Court that see this is the process which is going on. High Court will immediately give a direction to dispose the matter within 2 or 3.
Yeah, I understand all this. My question is, as an ordinary citizen,
Yes.
what can we do against such advocates? Because the stark difference that you see, you file an RPI against a PIL, against a secretary at a panchayat, and a hearing is scheduled at PTO's office. In the first hearing itself, they come and file a reply. So in such cases where they can file a reply in the first hearing, why can't they file a reply for 4 years at director of panchayat?
See, 4 years is a big time. It means they are trying to cause damage. But a couple of hearings, if the director is permitting them opportunity, you really don't have a say. But in a situation where they have dragged the matter for 4 years, what understanding I have is that if the High Court takes cognizance of this, High Court can also issue directions because nowadays in that garbage matter, where the secretaries were not in a position to take the matter and conclude it within time bound, It was taken up so aggressively that the secretaries were told to be present in the before the Honorable High Court, and they were also suspended. So if they are not doing their job, there are means to pursue them, but then sometimes it becomes, sometimes they it's unfortunate. But
So nothing is in our hands. We can't file any
you
complaint
can,
to
you have to pursue.
against the advocates, I'm saying.
You can, of course, you can file.
So they are
Section
one of
30
the reasons for all these, delay tactics, delaying the matters.
Section 35 of the Advocates Act clearly shows you when and in what circumstances you can file a complaint against advocate. If there is a provision of misconduct, if any malpractice or misconduct is proved by you, definitely yes, why not? And there are penalties also in that act. So it is no longer that much that protection is extended.
How complicated?
Sir? I'm sorry, sir. The counterclaim will have to be filed along with the written statement. Yes. To my knowledge, whatever I have practiced, it is in the nature of a separate suit. So, in my respectful understanding to what I know, it has to go with the written statement. Yes, I'm sorry. Yeah,
Yes,
So my question is regarding the advocates.
yes, sir.
What is happening? We are filing a case and an opposite advocate is representing two parties.
Okay.
But he has taken the wakalat from one party for which he were not knowing.
Okay.
Now the case is in their favor, for example. He had first the thing, he has to represent the other party, wakalat from police. He has not done. What can be done in this case with that advocate?
Now, see, advocate has not taken the wakalatnama for the other side.
Two parties were there. He usually won wakalatnama and he did not get the signature of the other party.
This should have been brought to the notice of the court earlier. Now the
Now
case is over.
under adhere, we have removed a document we got it recently. So what can be done to this?
Now there are two things. Whether there was any intention behind doing it or it was an error.
So it will be intentionally because it
So you have
topmost
to,
advocate.
it is got nothing to do with topmost advocate or bottommost advocate. Advocate is advocate. Now only what happens is to point them based on their experience, they point them as seniors, colleagues who are junior colleagues. But the rule book by which they are governed is one. So in case if you are in a position to establish that there was an intentional conduct by virtue of which some of his interest has been secured by him, you can file a complaint against him. But if you are not in a position, if it is proved that it was an error, then it is an error.
The second party is not coming for so many years for the case.
That's what I said. If at all you are in a position to justify that the act which is being played is nullified with some documentary evidence, then you can have your way through that aspect. If there is nothing on the record, then sometimes it, in your case, may not be an error, but sometimes error also occurs. Many times it has happened that I have fought a matter in the High Court without filing a wakalatnama, and then I get a call from the registry that there is no wakalatnama. So we realize when we draft a petition, sometimes it happens. So then we do it. But now, in case if there is any nullified conduct that has been seen, which you can show, then you have your way. Nowadays, the differences are more little than advocate both the parties. So,
Yeah, last question over here.
Can we get constructive ground to illegal construction? I sent the notice to Sarpanch. Sarpanch had been inspected and said why this construction should not be demolished. After that, there is silence. Meanwhile, he has rented to 3 Russian families and they are happen to be dealing in drugs. Sarpanch, therefore, am I responsible as a owner?
you have filed a complaint.
Complaint not that Russian has occupied. I have said the construction is illegal and they inspected and they have said why it should not be demolished because living there. Can I file a petition in High Court?
You can file a petition in the High Court and your relief in that petition should be that Panchayat has not granted any first asked for an RTI from the panchayat.
Yeah.
Whether any permission was granted to them.
Last 20 years, they have given me no permission, they have been granted in my property. So very good.
So that becomes one document. Yeah. Okay. Second thing is,
There I told them instead, in the inspection, I said this is illegal. Then they gave the notice to why this construction should not be demolished. Then it just stopped the political pressure.
I just share it. So basically, your problem is in your tenanted property, there is an illegal construction which is given on rent, despite your complaint and despite show cause notice having been issued, but thereafter they have slept over it. So that show cause notice is the first document. Sorry, your complaint and the show cause notice is one document. Thereafter, if the building is illegal, the electricity and water supply also they must have secured from health. Take that document. Why do you need electricity and water from health if it is legal? Third thing is, in case if they have rented out to some residents, file a police complaint expressing this particular doubt of yours. That is the next document. File a writ petition to the High Court seeking prayer of directing the panchayat to expedite the process of demolition. Meanwhile, see to it that the entire building is sealed and the parties are removed.
Sealing is done like
Sealing can be done by any authority, whoever is also.
including the
Yes. But if you go to the panchayat is not doing anything.
No.
So approach the High Court. High Court will immediately give directions. So the moment when you go to the High Court, make the director of panchayat the party, block development officer, secretary. And if Sarpanch is application, if there is any notice or letter which is issued by Sarpanch, then Sarpanch also party.
Sarpanch father is not complete.
So that is like in that case. I just share with you. In that case, there is a petition I have filed before the High Court, where Sarpanch's daughter has constructed an illegal construction, where Sarpanch was not there, and she has constructed, but the house number and everything is in the name of the father. So High Court took cognizance, and High Court immediately directed that the premises should not be occupied.
Sealing is should be compulsory.
For the purpose of sealing, it should become complete. This is not complete. Ground floor plus first floor was complete. Second floor, third floor was not complete. So they directed them not to occupy. They asked them to give the photographs of the advantage position, and the police was directed. Before the order, the police was directed that on holidays it should be noticed that no activity is conducted. So this is the best option, because if they are taking time and if these are the events, but you approach the police with your complaint saying that you have a doubt that this is what is happening.
Then, well, since it's very clear who the culprits are, and Adv.Girish Sardesai has probably told you like how to approach and whom to approach. He's made it very clearly with the hierarchy of courts. I would like to thank.
Thank you. It's if I make a will and I leave ancestral property, I have one husband and two children. So if I leave it to say one of my children, and nobody changes the will, then let's say I leave it to my daughter, she will get my house, or do they still have to go through inventory?
We have something called as period of limitation. If you make a will, and if every interested party is aware of it, there is a document to indicate that they are aware of that will. And it would be necessary, because tomorrow I will say, and I was never aware of it. So in case if there is a document clearly revealing that yes, the will was executed in presence of so and so, and they have never challenged it thereafter for a period of 3 years, then your will stands.
But what if I don't make a will and I die and my property will go to my husband and my two children? They will do inventory and they will be able to inherit it.
Yes.
So, on behalf of Goa Foundation and all the participants, I really thank you, Advocate Girish Sardesai, for especially stepping in so readily and at such short notice. Thank you very much. And I request Mamlatdar to give you a program.